And do yours. Really, Vincent? Seriously, you just throw your case on the table? No, never mistake my courtroom for your home.
Welcome back, everyone, and buckle up, because this case wastes absolutely no time pulling us straight into chaos. From the very first seconds, we're dealing with a volatile domestic dispute, serious felony allegations, and testimony that's already raising huge credibility and evidence questions. What we're watching right now isn't the trial itself. This is the preliminary examination, where the judge decides whether enough evidence exists to send this case to trial. And here's why that matters. At this stage, the prosecution doesn't have to prove guilt beyond a reasonable doubt. They only need probable cause. That lower standard changes everything. Defense strategy often focuses on poking holes early, while prosecutors aim to show just enough to keep charges alive. What makes this case explosive is the mix of alleged physical assault, a deeply controversial claim involving an unidentified object and conflicting investigative details. Already, we see the defense pushing hard on missing evidence, questioning scene investigation, and suggesting exaggeration or inconsistency. But don't blink, because what happens in the next few minutes sets the tone for whether this defendant walks toward trial on extremely serious charges, or whether key allegations collapse before they ever reach a jury. And trust me, the twists in this hearing are only just beginning.
All right. Court calls the case of the people of the state of Michigan versus Michael O'Leary.
Michael Vincent on behalf of Michael O'Leary.
Wait, this is the date and almost time for the continuation of preliminary examination in this matter.
Absolutely. Just to confirm, we are on YouTube, correct? Thank you.
Sure. Yeah.
At the last hearing, the people said I do not have any additional witnesses. Deputy Corona is here.
Mr. Benson.
Yes, I'd like to call Deputy Corona to the stand.
Did he? Benson? I wasn't listening. All right. Sir, please come forward and be sworn.
Solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God. See, state, spell your first and last name for the record, please.
Matthew Corona, MATTHEWKORONA.
May I inquire?
Deputy, how long have you been a deputy?
On the road 5 years.
Prior to that, jail?
2 years. Approximately.
Okay. And you've, last 5 years, you worked the road,
Yes, sir.
taking calls.
Yes, sir.
On February 9th, it started at the 9th and went into the 10th. Is that fair?
I started at midnight, so. At
Okay. Did you take a call at that address?
Sir.
Did you encounter a Jessica Kirkland?
Yes, sir.
And did she make several reports to you about a variety of incidents that she had with Michael O'Leary?
Now we enter the backbone of this hearing, officer testimony. Deputy Corona becomes crucial because he's recounting what the alleged victim told police right after the incident. And timing matters. Statements made close to the event are often seen as more reliable because memories are fresh and emotions are raw. But defense attorneys love moments like this because they can compare police reports against later testimony to find inconsistencies. Notice how questioning immediately starts focusing on specific wording: head versus face, how many punches, and how injuries match those claims. These details aren't random. If injuries don't match descriptions, the defense can argue exaggeration or fabrication. Also notice how the questioning is slow and methodical. Defense counsel isn't arguing yet. He's laying groundwork. He's trying to show investigation gaps. Was evidence collected? Were claims verified? Did officers follow standard procedures? Each unanswered question becomes potential reasonable doubt later. This slow buildup may feel technical, but legally, it's where cases are often won or lost long before trial.
Now I'm going to ask you about some of those. Were one of those incidents And it's in the police report, page 11 of your report. I want to refresh your memory.
Do you want me to move it up to a mic? He's got it.
Well, maybe I just read it to him and if he agrees with. It says in your report, Michael punched her in the head several times. Michael O'Leary. Is that correct? You remember taking that report?
I remember having that report. I can't say it was that set that report in my report. Yes, sir.
I'm reading it verbatim to you.
Yep.
And would you agree with me that Michael O'Leary is about 6 or well over 200 pounds?
Approximately, sure.
Okay. And Ms. Kirtland, more than one time told you that she was punched in the face, correct? Head in the face. Okay. Did she say both head and face?
I don't know.
Okay. Have you seen people who got punched in the face during 5 years on the road?
I would say so, yes.
Have you seen people who got punched in the face by a man 6'4", approximately well over 200 pounds? Do they, assuming the punch lands squarely in the face, is it your experience that causes severe injury?
Strong.
That's wrong.
I can't say it always happens or it doesn't always happen.
Does it happen? Sometimes so.
I'm sure it does, yeah.
And in your experience, have you seen people punched in the face by a large man several times? If you don't, can't recall, that's fine. Okay, all right. You heard a report.
Here's where defense strategy becomes crystal clear. They're trying to connect physics to credibility. The argument is simple. If a large man repeatedly punched someone, we should expect serious facial injuries. Broken bones, swelling, visible trauma. If the photos don't show that level of damage, defense hopes the judge questions the accuracy of the account. But here's the catch. Fights don't always produce textbook injuries. Punches miss, people block, adrenaline changes pain responses, and injuries can develop later. Prosecutors know that, defense knows that too. So this exchange becomes a subtle tug of war over what injuries should look like. And here's the engagement question for you. If someone says they were repeatedly punched but injuries look minor in photos, would you immediately doubt the story or assume circumstances might explain it? These are exactly the credibility battles jurors eventually struggle with.
That she was dragged or ended up near a stump on her property, which I think is, it's a kind of a half oval shaped driveway, gravel driveway. Do you remember that?
Yes, sir.
And there's a stump somewhere kind of towards the top of that oval near the house.
Somewhere on the property.
Do you remember her telling you that it was laying down there and something penetrated her that was cold? Do you remember? And do you remember her giving you any kind of detail about that?
Besides that, it was cold. She wasn't part of my.
She ruled that out, correct? Now, did you ever look for that? You and Sergeant Thompson showed up there also, correct?
Yes, sir.
And there was one other deputy that arrived. As a matter of fact, the deputy who ended up arresting Michael O'Leary. Did anybody look for that? I'm going to call it object.
I did not. I assume that other deputies did because I had an extensive conversation with Jessica.
Did you see anybody looking for that object?
I can't say that for sure.
Do you have any information that that object was recovered? If you did, it'd be in your police report, correct? So nobody told you that they recovered an object, because otherwise it would be in there. It's a pretty comprehensive report, and you'd put it in there. Do you know if a dog was called out to look for that object? Were you informed that Ms. Kirtland was on her period or begun her period at that time? Okay, you were told that, okay. Now, did anybody, to your knowledge, go around that tree stump, walk around it anywhere and look for that object? You remember a conversation in the barn?
This is a major turning point in the defense strategy. The alleged penetration by an unknown object becomes one of the most serious claims in the case, yet officers appear unsure whether a thorough search for evidence occurred. In sexual assault investigations, physical evidence collection is critical. Defense is emphasizing that no object was recovered, no extensive search occurred, and procedures may have been incomplete. The implication, maybe the alleged event didn't happen, or at least can't be proven. But keep perspective. Police often respond to chaotic domestic scenes with multiple priorities: medical safety, arrests, separating parties, securing environments. Evidence searches sometimes come later or get overlooked under pressure. Still, juries later ask, if this event happened, where is the proof? And when proof is missing, a doubt grows. This is the chess match between procedural imperfection and criminal accountability playing out in real time.
Between you, Sergeant Thompson, and Miss Kirkland. When Sergeant Thompson, asked about going to the hospital.
I can't recall.
Do you remember her asking, do you need to go to the hospital? And Miss Kirkland said, no, I've had concussions before.
I can't recall that exact statement, but I'm sure I asked her at one point if she wanted to go.
And then do you remember Sergeant Thompson asking her, no, this would be for a stain kit for the examination that the hospital does for sexual assault.
This part becomes emotionally and legally complicated. Defense wants the judge, and later the jury, to question why someone alleging penetration would refuse a forensic exam. Their implication, refusal suggests uncertainty about the claim. But trauma responses vary wildly. Some victims avoid hospitals due to fear, embarrassment, shock, or exhaustion. Others don't fully process what happened until later. Prosecutors often emphasize that refusal doesn't equal fabrication. Legally speaking, absence of forensic evidence weakens cases, but it doesn't automatically invalidate testimony. Many convictions occur based solely on victim accounts. The courtroom tension here stems from conflicting interpretations. Defense says refusal raises doubt. Prosecution says trauma explains it. This moment highlights how courtroom battles often revolve not just around facts, but around human behavior under extreme stress.
Do you remember her turning down that request? You don't remember that. You remember when you asked Ms. Kirtland, how did Michael O'Leary lose his front tooth? And she told you, I punched it, knocked it out?
Saying she punched him in the face, knocking his tooth out.
Okay. In your practice and training, is it usually the case that people who were sexually assaulted are requested to go to the hospital for a SANE examination? You know what a SANE examination is, correct? Which is a specialized nurse looks for signs of penetration of a woman's vagina. In your training experience, you recall that being the protocol? So it wouldn't be unusual for her to be asked to have a SANE examination. Do you know if she ever had a SANE examination? On your police report, I'll dial up the page. There's a section called Domestic Violence Supplement Report. Do you remember filling that out?
I did not know that.
Remember it being included in your report? Do you know who filled that form out?
Deputy.
Pardon me?
Deputy.
Did you have a chance to review it? You remember on there's like a breakdown of victim, suspect, relationships, medical treatment, things like that. You're familiar with the form, obviously. Now, on victim, it's checked alcohol. Would that mean, according to your training and experience, that means the victim had some type of alcohol in her system?
Such, yes.
Okay. Also, the word calm was checked. So do you remember that being checked for the victim? Okay. And down at the bottom, it says medical treatment is checked none. Do you remember that, seeing that? There's talk about consumption of vodka out of a vodka bottle. Did you ever recover the vodka bottle? No. There's an accusation that the security system was messed up, tinkered with, destroyed, and so I don't know exactly, but ruined or wrecked. That missed. Excuse me. Ms. Kirtland said that her security system had been destroyed by Michael O'Leary. Do you remember that? Was the security system ever recovered? You know if it was fingerprinted? Do you know that there was I forget exactly what you call them, those door cameras that record people going up to the door? Do you remember seeing that at the house? So nobody got a hold of a door cam, correct? To your knowledge? Okay. Now, there also was an accusation while Miss Kirtland was laying down by this tree stump that a motor vehicle came up to her so close that the bumper hit the tree, not her, hit the tree. Did anybody look around and take pictures of the tire tracks there?
I don't recall saying that a truck hit a tree, but I can also say I didn't look for tire tracks.
Nobody looked for tire tracks. Now, the weather conditions there, even though it was February, there was no snow on the ground, correct? And did anybody take pictures of the truck tire to see if there was grass on it?
I know I did.
Okay. Within the report, there were several mentions of her hair being pulled. The photographs that I've looked at, and I imagine you've looked at, shows Miss Kirtland with long hair. Did anybody collect any hair that was pulled out of her head?
I did not collect any loose hair.
Did you see any loose hair around?
I didn't observe any.
Did you look on the couch in the living room? Did you look in the truck? And nobody reported to you, I have a bunch of long brown hair. You're right, could I have a minute?
Yes.
So as far as you, there was no investigation on whether or not a large truck, there's a large truck we're talking about, correct? Yeah, pickup truck. Large wheels. If you remember, if you don't remember.
I can't recall.
No, it's okay.
That's also to interpretation.
Yeah. But as far as you know, there was no investigation of whether or not this large truck went off the gravel roadway onto grass in and around that stump we've been talking about. Okay. Thank you. Coming on your day off.
Really? Any questions?
Deputy, is this your report here? Your Honor, may I approach the witness with
You
this
may.
report? Thank you. Brought that up to you because I'm going to direct you to a couple of specific pages. First, I want to talk about the lethality report, the form that's a standard form that Deputy Knott filled out. Mr. Vincent asked you about the box that is checked with the word alcohol. Do you recall that line of questioning? And Mr. Vincent asked you, does that mean that a victim had alcohol? And then I didn't write out the rest of the question. Do you recall that? And your answer was something along the lines of, I believe so. Do you recall that? When you answered that question, did you understand defense counsel to be, generally speaking, when that box is checked, does it mean that a victim has consumed alcohol? That's how you were answering that question in the general use.
Yes.
You were not answering that question to indicate that this particular victim had consumed alcohol or was exhibiting signs of intoxication.
That box being checked. oversight on my part during review.
Should not have been checked.
Should not have.
Let's talk about the should not have been checked part. When you interacted with the victim, did you observe any signs of intoxication of her? Did you receive any evidence by viewing her or speaking to her that indicated to you that she was intoxicated by the use of alcohol? What about intoxicated by the use of any other substances?
This might sound minor, but documentation errors matter enormously in court. Defense attorneys love clerical mistakes because they create opportunities to argue investigative sloppiness. If police forms incorrectly indicate alcohol involvement, defense can suggest confusion, unreliable recollections, or improper procedures. Prosecutors must clarify quickly, which they do here. Showing the box was mistakenly marked. Why does this matter? Because juries look for patterns. One error may seem small, but multiple errors can lead jurors to question the entire investigation. At this stage, though, the judge's concern is simpler. Was there enough evidence overall? Minor paperwork issues rarely kill a case outright. Still, moments like this accumulate, shaping how credible the investigation appears later in trial.
Thank you. Thank you for clarifying there. Turning your attention to page 9 of your report, and let me know when you're there. Mr. Vincent asked you a couple of questions. He asked you about the victim telling you that she had been punched in the head or the face, and you said you couldn't recall exactly what you said. Recall this line of questioning? I'm on page 9 of 19. I'm in the last paragraph. And if Your Honor, if I may approach the witness, I can.
Yes, you may.
Thank you. I apologize for my time up there, Your Honor. I'm on
No, it's
page
okay.
9 of my report, and I want to make sure Mr. Vincent has the same copy as me. And he does.
Nine is a 29 on yours.
Yes, it's not the same 9 as Deputy Corona's, however. He's on a different 10. So, Deputy Corona, I have marked a little section there of where I'm at on our page 9 of your report. If you could read that out loud for us.
At which time Michael punched her in the head several times.
Thank you. That's taken from your section of your report where you are outlining what Jessica is telling you, correct?
Yes.
Hearing the officer read directly from the report reinforces consistency. Prosecutors want the judge to hear that this statement wasn't invented later. It was documented at the scene. Defense, however, may argue reports sometimes summarize statements rather than quote them exactly. Memory, wording, and interpretation all play roles. This is where courtroom storytelling becomes critical. Prosecutors build a timeline showing immediate reporting and injury documentation. Defense searches for exaggerations or contradictions. At preliminary hearings, judges don't decide guilt. They decide whether testimony, if believed, could support conviction. And here, consistent reporting strengthens the prosecution's position moving forward.
Thank you. I am going to turn to page 10 of my report. I'm still in the narrative of Jessica, so I'm going to come up, if Your Honor allows, to the witness
Yes.
stand. Thank you. Page 11, right?
Nope, I'm still on 10 now.
Perfect, thank you. So we're all on page 10, and I'm in the second to last paragraph.
Yeah.
And I'm going to start here. Thank you. Mr. Vincent asked you a line of questioning regarding the victim's statement to you about the penetration. Do you recall that line of questioning? I'm on page 10 of your report. I've outlined a specific section for us. Could you please read that into the record?
Michael pulled her shoes off and pulled her pants off and shoved something into her vagina. Jessica was unaware of what it was that was shoved into her, but described it as being cold and knew it was not part of Michael. Jessica confirmed the object.
Thank you. Just again to confirm, that is part of your narrative report of the information that Jessica provided you on scene. Thank you. Turning away from the report, you were asked a line of questioning about whether or not you searched the scene for an object that could have been used to penetrate Jessica. Do you recall that line of questioning? Fair to say there are a few other officers on scene with you. Sergeant Thompson, Deputy Knott, Deputy Lowe was not on scene. Was he in the hospital?
He went to the scene the night or the day after.
Day after. Thank you. Thank you. So he was on scene, just not that night.
Yes.
Thank you for clarifying for me. My apologies on that. You don't know whether Sergeant Thompson or Deputy Knott looked for an object that night. You don't know whether Deputy Lowe looked for an object the next day. Thank you. You were asked a line of questioning about whether you found, I'm going to use the word clumps of Jessica's hair on scene. Do you recall that line of questioning? At any point, did Jessica tell you that the defendant pulled her hair out of her head? If I were to tell you that I reviewed your report, and fair to say that nowhere in your report does it say that she said he pulled her hair out of her head. Thank you. Your Honor, if I may approach the witness with People's Proposed Exhibits 1 through 4, I have already provided these to defense counsel.
Okay.
Yes.
Do you have, is there a stipulation to admission? Or do you want me to lay the foundation?
Yes.
Thank you.
1 through 4 are admitted for
Thank
exam.
you. And I apologize, Your Honor, I'm purposely not using the screens because we're on YouTube and the sensitive nature of these photos. Deputy, turning your attention to Exhibit 1, could you please describe for the court what we're looking at here?
That'd be a picture of Jessica's face. She has some markings to her face as well as her neck and upper chest area.
Now, when you say markings, it would, if I were to use the word injuries, would that be an appropriate word as well?
Yes.
Do you see any type of redness anywhere?
Yes.
Where do you see redness?
On her neck and just above her, the line of her t-shirt.
And what am I seeing here on her nose?
Photos anchor testimony in visible reality. Jurors later see these images and compare them with verbal descriptions. Defense attempts to minimize injuries, suggesting they don't match severe assault claims. Prosecutors highlight every bruise and mark to support the narrative of violence. Visual evidence carries enormous emotional weight. Even minor injuries can appear dramatic when displayed in court. However, defense points out what's missing: broken bones, major swelling, or severe facial trauma. The fight now becomes interpretation. Are injuries consistent with claims or exaggerated? These interpretations often divide juries, making injury evidence powerful yet contested territory.
I don't know if that's dirt or blood.
Thank you.
Some type of a foreign object, not skin.
Thank you. Turning your attention to People's Exhibit 2. What are we looking at here?
Jessica's her right forearm.
And how about her elbow? Do you see that in the photo as well? What's noteworthy here?
There's redness to her elbow.
Thank you. Turning your attention to Exhibit 3. What are we looking at here?
Jessica's left leg and knee.
And what is noteworthy here?
Say redness to her knee.
And turning your attention to Exhibit 4. What are we looking at here?
Once again, Jessica's face, the inside of her upper lip.
Could you describe what we're looking at here on the inside of her upper lip?
It looks like a large blood blister.
Your Honor, may I approach and present those photos to Your Honor?
Yes.
Thank you.
Thank you.
Your Honor, I have no further questions for this witness.
Any redirect, Mr. Benson?
We here earlier when Ms. Kirtland ruled out anything about Michael O'Leary as far as this mysterious, or what, I don't know what to call it, objects you talked about that penetrated her. Were you here for that? Just about, I think a week ago, about a week ago. Okay. Now I've got the same bunch of photos. And you've been asked to look at some of the pages. My copy's all marked up. I refer you to the prosecutor's page 10 of 19. Do you have the report in front of you? Could you look at the first paragraph on top of page 10?
I believe my page 10 is different than your page 10.
Well, I'm looking at the bottom left-hand corner.
Yeah,
It says page 10 of 19.
yes, but earlier when I was asked the question, my 10 was different than.
I understand. I'm asking on this page 10 of 19. Do you have that?
I do.
I'm going to refer you to the top paragraph.
No, he doesn't have that. He can have mine though. I have 2 copies. Let me just get
We have mysterious, besides mysterious objects, we have mysterious police reports.
Mine also has markings, so you know, but he can have my copy.
I can just read it to them to save everybody some trouble. It says, not the first paragraph, sorry, the middle paragraph. And I'll read it.
Okay.
Michael was still hitting her in the face. Do you see that?
See that? I have the same report as him.
Right here.
Redirect questioning allows prosecution to repair damage done during cross-examination. Here they reinforce the idea that multiple strikes occurred. Defense argues injuries should look worse if repeated punches happened. But physical altercations vary. Angles, defenses, and timing all affect outcomes. Here's a key viewer question. If injuries don't look as severe as expected, do you assume exaggeration or accept that fights don't always follow predictable patterns? Jurors often debate this exact point intensely. Redirect is about restoring confidence in the prosecution's narrative before the witness leaves.
You need my glasses?
No, I see now. I
Okay.
see. Oh, you're not at the beginning. You're at the end of a sentence. Okay. Can I approach and get him on the same? Can I?
Hey, sure. Anything that would help get everybody on the same page as Michael Vincent.
I will admit, it's kind of hard to read it,
No,
but I can read.
we
it.
were all just breathlessly waiting
I'm
for you to
open
start
here.
reading.
Okay, we're on the same page.
We're all, everybody on the same page.
All right, we are?
Again,
Okay.
Michael was still hitting her in the face. That was understood, I think. That means it was more than one punch because he was still hitting her face. It was still going on. You agree with me?
Yes.
Well, I'm reading what you put in there.
Defense counsel draws from personal experience to argue expected injury outcomes. It's persuasive rhetoric, but not necessarily scientific evidence. Every fight differs. Punch strength, accuracy, resistance, and environment all influence injury severity. Prosecutors may later counter that anecdotal experience doesn't invalidate a victim's account. Still, this exchange plants seeds of doubt. This is courtroom storytelling colliding with personal credibility, and both sides know jurors often respond to relatable experiences.
And I've looked at these photos. You have them in front of you. I have probably more experience than anybody in this courtroom about getting hit in the face or hitting somebody in the face.
Yeah, that's probably true.
Thank you. And I'll be blunt with you. I mean, I used to box. I was a street cop for years, and I've seen a lot of people his size and even smaller. Stand up there, Mr. O'Leary, so everybody can see how big you are. All right, you can sit down. Somebody his size, I have a grandson who's his size who boxes. You hit somebody in the face, they mess the face up. They'll break a nose, break an orbit, close an eye, the face will be marked up, not a scratch here or there. And there's no sign of that in the pictures. Do you agree with me? The pictures you took, the description I just gave, is that in any of the pictures you looked at?
Can't see bones in the pictures.
Granted, but you can see those eye closed. You can see nose bleeding. You can see swelling after you get hit in the face. It's a big, powerful man.
Not at the exact time those pictures were taken, no.
So you didn't see anything like that. When the pictures were taken,
Shot, I did not see it bloody.
that's my question. Thank you. Remarked about her neck. This picture, you got it in front of you. In the police report and in earlier testimony, Ms. Kirtland testified that she was pulled out of this truck. Apparently there was 2 or 3 incursions in the truck where they were fighting with each other. You remember her telling you that? That she got in the truck to prevent him from leaving. And then 2 of them fought inside the truck.
Defense now suggests injuries may stem from chaotic mutual struggle rather than one-sided assault. If both parties fought, blame becomes complicated. Jurors often struggle with mutual combat situations. Who escalated first? Who acted in self-defense? Prosecutors argue escalation and severity still matter, even in fights. This stage reveals how messy real-life conflicts appear compared to simple legal narratives.
She got pulled out of the truck. And she testified she got pulled out by her neck. Now, and you're familiar with the phrase where the head goes, the body goes, right? The marks on her neck, you don't know where they came from, do you? They could have come from being pulled out by her neck out of the truck.
I suppose, but I don't remember her stating that she was pulled by her neck. I have to look at my report with that exact statement.
It's earlier testimony. If somebody, let's put it hypothetically, just to not put you on the spot about that. Hypothetically, if somebody's pulled out by their neck, particularly a fair-skinned woman, it's going to leave some marks on her neck. Would you agree with that? Thank you. Were you in charge of the scene, or was Sergeant Thompson in charge of the scene once she arrived?
I was the officer in charge.
Okay. So she wasn't actually in, she was there for a supervision or assisting you. Is that fair?
That's an odd question. I was the officer in charge.
I'm just trying to find out what her role was. I don't mean to interrupt you, but what was her role when she arrived there?
She assisted in the investigation.
Okay.
She's also a sergeant.
I understand. Boy. So do you remember her directing you or anybody else to look around that tree stump for this object? Do you know if she directed anybody? Did you ever hear her say, scour that area for this object? All right, thank you.
Are you done?
Sort
Further questions?
Yeah, all right. Sir, you may step down. Go back to your day off. Oh, thank you.
Thank you.
We can release him, right? He needs to sleep.
Okay.
We can release him. He needs to sleep.
So,
He can leave.
thank you.
Yes, he's released. Yes.
With the officer off the stand, the legal focus shifts from testimony to motions. Both sides now summarize evidence strengths and weaknesses. Judges at this stage must decide whether enough probable cause exists to move forward. This transition marks the end of factual testimony and the beginning of legal argument, where lawyers interpret events rather than describe them.
Thanks.
Do you have any other witnesses?
Nope.
Any rebuttal witnesses or the people?
Your Honor.
All right, motion.
Thank you, Your Honor. At this time, we're going to motion to bind over the information. However, in the interim, we received the defendant's blood results. I am going to be adding misdemeanor count 8 high BAC. I have provided the additional discovery to that effect to defense counsel, so my office will issue an amended information. However,
With an added count 9 of high BAC.
yes, I apologize. I think I said 8. Yes, added count 9 of high BAC.
Could I inquire if the blood test came back 17 or above?
Oh, I apologize.
Well, it would if it's a high BAC.
No, I apologize. It's a 0.169. I apologize. Thank you.
Is 169?
Yeah, it's the 167. So
167.
I have the 7 and 6.
So it can't be.
Thank you. It's a note WI. Thank you.
Thank you.
Thank you.
Okay. Well, that's all you had to say.
One and only
Don't
time.
look so smug like you did something.
In terms of the motion, thank you, Your Honor. The people will motion to bind over on all of the felonies as written. Thank you.
Your Honor heard the testimony last week and about this mysterious object. My recollection is reviewing the testimony from last week. She never connected this object to Michael O'Leary. We don't know what the object is. We don't know if this type of object exists. We don't know if Kirtland ever had any kind of physical evidence because she refused to go for a SANE test. I have been doing this for a long time. This is not a CSC. I don't know what it is. It's not a CSC. No effort was made to look for that. The only thing I can,
Defense attacks the sexual conduct charge directly, arguing lack of evidence and credibility issues. They emphasize missing forensic proof, refusal of exams, and investigation gaps. Prosecutors argue credibility decisions belong to juries, not judges. Let me ask you, should serious charges proceed based primarily on testimony, or should physical evidence always be required? That philosophical debate surfaces repeatedly in criminal courts. Judge Simpson must decide only whether evidence could support conviction, not whether it ultimately will.
put together on that is that they didn't buy this mysterious object any more than I'm buying it. No effort was made, no dog was called, no put a spotlight on the scene, nothing was done. Nobody even looked for it, let alone did a comprehensive search for it. It's clear that testimony, there was a fight between the two of them, at least 2 to 3 times. Great bodily harm. The driving charge up there. So I'm going to object to find over on the CSC. I understand the rest is a question for a jury. Who started the fight? How long ago? Was it really great bodily harm? Those are issues for a jury, but just simply not enough to bind over. There is no proof anything happened to this woman.
Other than her testimony.
Other than her testimony, granted.
Okay.
And I think the testimony is far from credible. She said, this happened. She can't describe anything except it was cold. And she clearly rules him out. One of the last questions I asked her, we're ruling him out, right? Yes, she agreed with me. Ruling him out. If it's not him, it's not his body in her.
Oh, okay.
Okay? Rules him out.
Right, but that doesn't mean that it wasn't a CSC.
And also, there's got to be something there to bind a man over on a CSC one, absolutely one of the most serious charges, when all that could be said, some kind of mysterious object that nobody got any kind of proof other than her saying that. And that's it, nothing. That'll be some clue.
But that then becomes a question of fact for the jury, doesn't it?
I think it comes a question of credibility at this stage. I think it's a credibility issue that this court could rule on, that testimony was simply not credible. I've never heard any kind of testimony like that.
Okay,
But
but
the court hasn't either.
there's a lot in this case I haven't heard before, but I'm just saying that I understand your argument, but what you're asking this court to do in that instance is resolve a question of fact. You're not asking me, I mean, and I don't believe that I can do that at this stage. I mean, if somebody were to find her testimony credible, then it's
Well,
what it is.
I'm asking this court to find her testimony not credible and not provable. But I even asked anybody look at the grass over there? Anybody see that she was laying next to a tree stump? Nothing, absolutely nothing.
You might have arguments regarding the investigation. You might have other arguments regarding what she said, what she is saying. But again, those are questions I think that have to be resolved by a jury. I don't believe that I can resolve it at this point.
I don't want to keep.
Judge Simpson emphasizes that credibility determinations belong to jurors. Preliminary hearings aren't mini-trials, they're gatekeeping proceedings. This decision keeps all major charges alive, dramatically raising stakes for the defendant. Defense loses a key early battle but preserves arguments for trial. Prosecutors secure momentum moving forward. This ruling illustrates judicial restraint, allowing juries, not judges, to weigh disputed facts.
Say this.
But you will.
My question is, that her testimony about having some kind of mysterious object penetrate her is simply not credible. And it's not proven by any kind of physical evidence at all. And she turned down going to a sanity tip. This woman has court experience. She works for a criminal defense attorney. She's worked in the courts for a number of years. She knows what a state test is, and she didn't want one. Why? Because she knows it was going to show nothing, nothing at all. And that's not what she wanted. She wanted to bury this man. Thank you, Your Honor.
I don't know that I need a response, but if you want to, go ahead.
I really want to,
Okay, go ahead, and you may respond.
but I know when not to mess with this thing, Your Honor. Thank
Oh.
you. Thank you.
The court has heard the testimony in the case. There isn't a dispute as to the counts 2 through 8 and with, well, 2 through 6 to the felony counts. The court does believe as to those counts, that people have sustained their burden shown by probable cause that those offenses were committed and that the defendant committed them. As to count 1, the CSC, which is the crux of the defendant's argument regarding bind over,
This moment officially sends the case toward trial. Charges survive scrutiny, meaning jurors will eventually hear everything. The judge acknowledges conflicting accounts but rules evidence meets the probable cause threshold. Defense strategy now shifts toward preparing trial defenses or negotiating possible plea deals. Prosecutors prepare to present evidence more forcefully later. The courtroom tension transitions from preliminary filtering to full trial preparation.
Ms. Kirkland's testimony. Ms. Kirkland's testimony was very clear in terms of what she experienced and what she said happened to her at that time. She relayed that to the court regarding the penetration by an object. It would seem to me that should she have really wanted to bury this defendant, she could have very easily, if she were making it up, I guess one analysis would have been to say that it was him instead of some object. She didn't do that. She relayed what she had. It doesn't really become an issue of credibility. It becomes an issue of who's going to be believed regarding it, well, whether or not she's believed, because it really isn't a counterbalancing story. So for those reasons, the court believes that that is an issue of fact that needs to be decided by the trier of fact, that being a jury. Court would also find that the people have sustained their burden as to count 1 and therefore would bind the defendant over on that charge also.
Mayor, here's fine, Your Honor.
Well,
Can I approach before we address bond?
yes.
But I think we interrupted you. Was there something else before we?
Everybody's been interrupting me. So he's bound over on those counts. You acknowledge receipt of the information waiver.
I have not received it, but that can get to me. I know the charges. He stayed mute to those charges.
Defendant having stood mute, waiving formal reading, court will enter a not guilty plea. And yes, as to bond before I set the pretrial date.
We may approach, Your Honor.
Yes.
Thank you very much.
I need an end date. Pretrial will be set
April 30th at 1:30 before Judge Comfy.
April 30th, 2024, 1:30. As to bond in this case, the court looks at the bond. I've heard the testimony in the case, and conceivably the bond might be appropriate, but it's well out parameters of what typically would be set. So I will reduce the defendant's bond. Currently it's set at 10 million cash surety. I will reduce it. I'll cut that in half to 5 million cash surety. Thank you.
And that brings us to the conclusion of today's dramatic hearing. Judge Simpson ultimately rules that enough evidence exists to move forward on all major charges, including the most controversial allegation involving penetration by an unidentified object. The defense succeeded in highlighting investigative gaps and evidentiary weaknesses, but not enough to stop the case from advancing. Those credibility battles will now play out in front of a jury, where testimony, injuries, investigative conduct, and conflicting interpretations will be tested under the highest burden of proof. Bond reduction also signals the court balancing seriousness of charges against procedural fairness. The defendant remains detained under extremely high bond conditions while awaiting trial proceedings. This case highlights how messy real-life incidents collide with structured legal systems, where truth, perception, evidence, and human behavior intersect under intense scrutiny. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.